As I think everyone can anticipate, this is not an easy decision for the court. There are many competing interests and very important interests for everyone who is involved in this case. I think the state said it, it's not a slam dunk either way. This case came before the court for the first hearing on March 11th. Now, that certainly wasn't the first hearing for this case. This case was charged on November 23. I would note that at that time, attorneys Perry and Keyes were with Mr. Brooks at the initial hearing. Time limits were waived, and ultimately a preliminary hearing was held in January, I believe on January 14th. So there was a little bit of a delay in getting this case to the trial court, but I would not call that a long delay for maybe folks who aren't familiar with the criminal justice system. For anyone who is in custody has a right to a preliminary hearing within 10 days, and that was waived. In addition to looking at some case law, the court, of course, looked at the facts of this case. I've heard from Mr. Brooks's attorneys today. I've heard through their filing. I've heard from the state, and I've heard from the families of 13 victims. A motion for continuance is a matter that is within the sound discretion of the trial court. And I am primarily going to be citing from a case, State versus Woolman, which is a Wisconsin Supreme Court case from 1979. It's found at 86 Wisconsin 2nd 459. And there's a lot of other sites that they have within that, but I'm not going to go through all of the individual sites, but all of this is found in that case. Now, a denial of a continuance potentially implicates the Sixth Amendment right to counsel and the 14th Amendment right to due process of law. So this court needs to balance Mr. Brooks's constitutional right to adequate representation of counsel, and of course his due process rights as well, against the public interest in a prompt and efficient administration of justice. Now, of course, when this case was authored, which was in it was submitted in November of 1978 and decided in January 9 of 1979. I would note that 1979 is when the first victims' rights legislation, I believe, was passed. And so it's very likely that when the Supreme Court decided this case, they didn't have the language in Chapter 950. And of course, they didn't have the more recent amendment, what we all refer to as Marsy's Law in 2020. So I would put forth that the court also needs to balance not just the public's right to prompt and efficient administration of justice, but as the state points out, there are victim rights as well that are implicated. And that's found in the Wisconsin Constitution, Article 1, Section 9, and then as well in Section 950.04, sub 1V, sub K of the Wisconsin statutes. But I also kind of took a step back and I looked at what are my obligations of a judge in any case. I am guided in part by my case disposition goals that have been established by the Wisconsin Supreme Court and other judges who have sat on those committees that concern those things over the years. And while these are not hard and fast rules, they are goals that every judge should aspire to. 85% of my felony cases should be resolved within 180 days. 95% of my felony cases should be resolved within 360 days. I think that is because in the backdrop of all of this are some very important constitutional rights. The United States Constitution in Amendment 6 talks about the right to a speedy trial. Wisconsin Constitution, Article 1, Section 7 echoes that right. Wisconsin statute 971.10 also has a statutory right to a speedy trial. It is a right that is a very quick right, shall we say. For a felony case, if a speedy trial demand is made, it requires the state to bring that case on for trial within 90 days. In addition, I've already mentioned the constitutional provisions dealing with victim rights. And of course, there is the United States Constitution, Amendment 14, which talks about due process. We know from those provisions and the cases that interpret those provisions that speedy trial attaches at the time of arrest or when officially accused of a crime. So in this particular case, that would be the date of his arrest on November 21 of 2021. Of course, he was quickly charged on November 23 of 2021. When this court held its first hearing in this case on March 11 of 2021, I honestly did not anticipate scheduling a trial date. But when the state asked this court to consider utilizing the jury questionnaire process to assist with the change of venue issues, I thought it prudent to really schedule it for trial and work backwards from there. Now keep in mind that trial date is scheduled presently for 7 weeks shy of the 1-year mark of this incident. I talked a little bit through my questioning of the parties about that change of venue motion that was brought and the implications if a trial is adjourned and what that means for the process here in Waukesha County. While not by any stretch of the imagination an overriding interest, the county has already expended some resources in putting forth those jury questionnaires, the initial jury qualification questionnaire over and above what we would normally do, and certainly in advance of what would typically be an October trial date. We would normally do that about 6 weeks ahead of any particularly scheduled trial week. And again, it is not an overwhelming consideration, but I think it's an important consideration because it attests to the court's willingness to also make this case a priority and to do things such as expending the resources of the county, utilizing the clerk staff in order to get all of those things put together, and of course, scheduling the time for not just this court, but for the parties. And I certainly want to acknowledge that both sides have been very diligent with that particular issue, really moving very quickly to file those proposed jury questionnaires and hold a hearing on that. We are very close to finalizing those jury questionnaires. I also want to be mindful that I have 2 very experienced and well-respected defense attorneys before me who are making this request to the court. They are telling this court that they do not believe an October trial date is feasible. They clearly understand their obligations to Mr. Brooks regarding investigation, review of discovery, analyzing defenses. They, of course, have already filed the change of venue motion, understanding the time limits for filing such a motion. As I've already indicated, they were very diligent in filing their proposed jury questionnaire and cooperating with that process. I also know that the state has been very diligent in their responsibilities in providing discovery information. That's why I asked the question early on about the statement in the state's reply to this motion and whether that was accurate or the defense wanted to provide any additional information. And I believe Attorney Perry's words were it was generally quite accurate. And what do we know from that? The preliminary hearing was held on January 14 of 2022 at the request of the defense. On January 20 of 2022, discovery consisting of over 1,300 pages was sent to the defense. And on February 9 of 2022, there was a 2-page supplement report and 2 crime lab reports that were provided to the defense by email. An arraignment was not held until February 11. That is notable because in the vast majority of cases, the state does not, in my opinion, you can correct me if I'm wrong, turn over discovery even before arraignment. Usually a plea needs to be entered, but the state did that. In addition, a link was provided to the defense on February 15 of 2022, giving them access to all digital video recordings, 302 items in total. A follow-up report was sent on March 1, consisting of 144 pages, and then an additional 500 pages were sent on March 17th. There was a very specific discovery demand made by the defense on March 29th related to the toxicology discovery packet, and the response from the state was provided the very next day. We learned today that the one piece, and shall I say pieces of information that are yet to be turned over involve the DNA analysis that was conducted in this case. And to the state's credit, they did indicate it's not simple, it's quite lengthy, but that all the analysis has been done, and they anticipate that report being turned over within the next week. So all of these things are facts that this court must look at when balancing all of the important interests. The interests of Mr. Brooks, the interests of the state, of this court, and of course, the victims. Prior to even deciding this motion today, I spent some time looking through and preparing a trial order. The parties themselves have a draft. But when I look through that order, and typically what I do is when setting a trial date, and most courts do, we work backwards. We look at when a trial date is set, we then set a jury status date, and then back up from there with various motion dates, the exchange of witnesses, expert witness filing dates, etc. And in my court, of course, there's always the requirement that the parties provide their voir dire questions. And although it was a little bit unusual for this court to set a trial date at the first court appearance, it is not unusual for this court to do its best to adhere to the 1-year case disposition goal in felony cases. Now, I am not here to tell the public or the parties that that is a goal that has been met in every single case. Certainly over the last 2 years, that has been challenging. But it would also not come as a surprise to everyone that it is incredibly important to this court to make sure that cases come to finality as quickly, as efficiently, and responsibly as possible. So when I balance all of those interests and looking at the time that we have available between now and an October 3rd trial date, and understanding that it's my opinion, based upon the information that was provided here today, that perhaps a couple of weeks delay after October 3rd, that really there's not a whole lot of time that could be devoted to this case after November of 2022 by the defense due to some other important obligations for Attorney Perry. He himself, and I appreciate the forthrightness, said that December would not be feasible due to his trial obligation in Kenosha that is set to start on January 5th and run approximately 5 weeks. That is a case that, of course, has a significant amount of age to it. And I weighed that as well because no one wants to do cases more than once. And if that's not a case that demonstrates the difficulties that can befall everyone, not just the court, but victims and prosecutors and defense attorneys, I don't know what case would. But that did not dissuade this court from looking at and maintaining the October trial date. This court is willing to give the defense a start date as late as November, so about 30-day adjournment. And I know that will be challenging, even for everyone involved, in the sense of that will be, of course, coming up on the 1-year mark. There are oftentimes, I think all of us sitting in this room who are attorneys and of course the court have some type of continuing education within the month of November and sometimes even into December, but I'm willing to forgo those things as well to make this case and to continue to keep this case as a priority. So for all of those reasons, I am going to deny the request for a continuance. With that, I would like to address some additional issues because I do want to finalize as best as I can a trial order. Keep in mind, I am fully aware the court has yet to decide the change of venue motion, but as I have told the parties, I'm really proceeding on somewhat of a dual track, meaning it is proceeding as if this case stays within Waukesha with this court with a trial date in October, but also understanding there is a very important motion before the court that could implicate when this trial is held. And I just don't want people to be disappointed if at a later point in time the decision on that motion alters when this trial takes place. So with that, I have spent some time looking through some important dates. The first will be when to finalize the jury questionnaire and when to get that out. I appreciate the defense has filed a very thorough track change document today under seal that has some suggested changes. I'm hoping the state has had an opportunity to review that. They're not very lengthy, but with your approval, I would like to make those changes so that this questionnaire can be finalized.
Yes, I did review the document submitted by the defense. We have no objection to any of their suggestions, Your Honor.
All right, then all of the suggested changes will be made, and I will work with the clerk of court's office to finalize that and mail that to prospective jurors by April 15th. I am going to have those questionnaires due no later than May 13th. And I will have all of those questionnaires put on a flash drive and distributed to the attorneys no later than May 23rd. I am proposing a June 10th deadline for a supplement to the motion by the defense and a simultaneous state's reply or response, as the case may be. I do expect both parties in their supplement, well, the defense supplement and then the state's response to address victim rights. I think that's an important consideration with the change of venue given Marcy's law. And then I'd like to propose a hearing date on the change of venue motion the week of June 20th. Before we decide that, does anyone have an issue with the deadlines I've just proposed from the state?
No objection to that. Attorney Basie just reminded me that her and Attorney Witchow are special prosecutors on a Kenosha County case that will be in trial June 20th.
Correct.
But if necessary, I could appear for that change of venue motion if that's the only option, and we could split up.
How about from the defense?
Those dates are fine.
Can the defense make a hearing on the week of June 20th?
Yes.
My preference is June 20th in the afternoon. And second would be June 22nd in the morning. And if those don't work, I have one other time spot.
The 20th in the afternoon works for us. The 22nd in the morning does not.
I just want to confer with the victims, Your Honor. Anybody have any significant challenge on Monday, June 20th in the afternoon for the change of venue motion? Okay, everyone in the courtroom's indicating that afternoon's acceptable. I am available at that time, Your Honor.
Thank you, and I do appreciate the willingness to do that without your co-counsel. At this point, I do intend to maintain the jury status hearing that I've already scheduled for September 9th at 1:30 p.m. I will be setting a pretrial motion deadline of August 1st. And if the parties are available, I would like to give you a motion hearing date. I will make myself available the entire day if need be on August 26th. I have that entire week right now, but I was trying to give you all as much time as possible and give the court as much time as possible to also review any motions that come in.
The 26th is fine with us.
Yes, the 26th is agreeable to the state, and again, all the victims present in the courtroom have not voiced any objection to that, Your Honor.
Thank you.
That'll be all day, you said, Your Honor?
I will set aside all day.
Okay.
I know the state previously has said the state would be ready to go to trial in short order, so rather than do simultaneous witness exchange, I was going to ask if you could file your witness list sooner than the June 1 date, perhaps even by May 1.
Yes.
Would you be able to name both lay and expert opinions by that date?
Did you say opinions or witnesses?
Sorry, witness,
Yes.
witness lists. Obviously, if it's an expert, you have to have a summary of their
report.
testimony or opinions. That's why I said that.
Yes, so we expect we will be able to do that, Your Honor. Should there be any challenge, I will alert the court.
I would like the defense to file their lay witnesses by June 1st, and then disclosure of expert witnesses by July 1st. Do you wish to be heard on that?
I guess I'd object for reasons previously stated.
Understood. There will be language in the trial order regarding jury instructions, and then any additional voir dire questions by August 30th of 2022. Now, the one piece of this that I don't have yet would be when we would have a conference on the returned jury questionnaires, again, presuming the court keeps everything, we keep going forward. That is something I can add to this trial order today, or we could discuss after the court decides the change of venue. Any thoughts on that from the state?
Could you clarify, Your Honor, I wrote down a June 20th motion date for the change of venue,
Right.
and you're talking about just
I'm
all
talking,
getting together to confer about the questionnaires?
I'm talking about in the event there's a denial of the change of venue, right? The two tracks that I'm taking here.
Okay,
At some point with the jury questionnaires, they will also be needed to streamline the jury selection process for the October trial. And so at some point, the parties, whether it's a meet and confer to do strikes for cause, from that, and then a determination is made in consultation with the parties as to how many jurors come in for the October trial for in-person jury selection and questioning. So that's the one piece I thought perhaps we could address later.
yes, I would agree, but I think we should schedule something. Or would you prefer we do it off the record?
No, I can add that in. That's just the one,
Okay.
just being honest, just ran out of time on that one and wasn't quite looking at my calendar long enough to get that particular date factored in. It probably would need to happen in July or August.
Sure.
And the only other thought I had on that is whether we, depending on motions that are filed, we could use that August 26th date for jury questionnaires as well. And maybe schedule a second day if we need to go beyond that, whether it's for motions or the jury questionnaires. Are you all tracking me?
Yes.
Okay,
Could we maybe do the 25th and 26th?
that's fine. Would the defense be available for that?
It's fine, let's just do that.
Right, because I'm assuming we want to do it well before the jury status hearing, which is only a couple of weeks later on the 9th. All right, so we'll use, what I will put in the order will be a requirement that prior to the motion hearing date and jury questionnaire conference on the 25th and 26th, that the parties meet and confer on any strikes for cause that you all agree to. Does that make sense?
Yes.
Attorney
Yes.
Perry? Okay. I think I've covered all the dates that I need to cover in the trial order. I will be finalizing that and will obviously upload that to the e-filing system.
Your Honor, would you consider adding a deadline for the defense to enter a special plea, if any?
Attorney Perry?
I'd object to any deadline on that, aside from just Mr. Brooks's rights in the Wisconsin statutes.
I respect that. Obviously want to make sure the case does not get delayed because of a entry of a special plea at a too late of a date. And I think understanding that right now what I'm seeing with the doctors is at least 60 days for reports and analysis. This may very well take longer if in fact a special plea is entered, just given the volume of discovery, but at this point, I'll set a deadline of July 1. That should give ample time. That doesn't foreclose this defense, of course, from pursuing it on their own without, that's just to seek a court-appointed doctor. I realize the state would want, may very well want an evaluation, but we're getting a little bit ahead, so I'm not going to discuss that any further. Any other dates either party thinks I have overlooked?
Not dates, I have two other issues for the court before we conclude, Your Honor, but nothing on dates.
Anything as to dates, Attorney Perry?
No.
All right. I have some other things as well, but I'll hear from the state.
Two things, Your Honor. For the questionnaire, it does indicate you're waiting for the state to provide the victim list of names, and I have that prepared, Your Honor. I wanted to discuss this with the court one more time before I filed it. It's ready to go. I can hit a button and you'll have it, but several of the families have expressed significant concern with having their children named. Now, I understand the jurors, the potential jurors, will be told they are not to disclose this information whatsoever, but the majority of the names on the list are children. So I just wanted to bring that to the court's attention again. I really don't have a good workaround for that because other than to say it really doesn't go to the change of venue motion. So it could be something that we give to them much later, much closer to the trial date. Again, I think the concern is if we send it out now in April, at least in theory, that list is out there floating around for months and months. They're told not to disseminate it, but that's the reality of it. So if the court orders me to do it, I will certainly do it. It's ready to go. But that is the concern that many, many families expressed about naming their children.
I do think it goes to the issue related to the change of venue if the defense wants to be heard further. And I understand the family's concerns, but with so many victims in this case, one of the issues that has been raised is whether a jury can be found in this county and whether, given the reach of people, you know, it's often been described that we're all 6 degrees separated in one way or the other. And I think it's important that people see those names. They may not, it just has the potential to tell us, the court and the parties, who in the community has some connection. I realize, I think what some people might think, and it's not really wrong, is that if you know someone and if someone in the community knows one of these children victims, they're going to know them and they're going to know their name and there are other questions. I want to err on the side of caution. There is a very strong, in all caps, in bold and highlighted, it's going to be printed in color, about the importance of keeping this confidential. They can't copy this, they can't keep it, they can't distribute it. So I feel that those protections are sufficient, and because they are named victims in this case, it's important to have that information out there. I appreciate that, but I am going to order the state to turn that over.
Okay, understood. We will have that filed today. My computer just died, but Attorney Basie probably can. And then my last comment for the court was the reply or the response that I filed this morning to the request for the adjournment. I did file it under a temporary seal. I did that out of an abundance of caution in case there was anything in there that the defense found objectionable or did not want made public. I don't object to the court unsealing it. Maybe the court didn't even seal it, but I filed it under a temporary seal. So I just want that on the record. that we wanted the defense an opportunity to voice any objections if they wanted to. I don't believe their original motion they filed under seal. And I think we've discussed a lot of the things that are in them.
Thank you, because I was given a copy that did not have that watermark in preparation for today, so I appreciate you bringing that to my attention. What's the defense position?
We don't have a request on that.
All right, then I'm going to unseal the temporary and make that part of the official record. I think that's important. On that note of sealing versus not, it obviously, as this case has progressed, this court has had the parties file under seal their proposed questionnaires. And I wanted to make a record that even though in Wisconsin, anything that's filed in court, unless there is a statutory requirement or constitutional requirement for confidentiality, is part of the open record. Now, these jury questionnaires have very sensitive questions, and ultimately the questionnaire we utilize is going to have victim information. Also, under the statutes, the completed questionnaires are maintained as confidential. And so, on balance, I find that it's important in this case to keep even the proposed questionnaires filed under seal so as to maintain the confidentiality of the any victims' names that are utilized in there. But also, I think, too, when we think about, in part, why I am using this questionnaire at this point, and that is to help the court gauge and assess the change of venue motion. And I think I would not want this questionnaire, reported on at length. I wouldn't want its contents to be disseminated ahead of people getting this questionnaire. Because, again, it relates to potential jurors, all of those things, in my opinion, weigh in favor of sealing. And so all of those documents I will maintain under seal. That, of course, was the first point of your motion on process. We had only addressed the second point at the last hearing. I briefly want to address, you had asked that eligible jurors be summoned in to complete the questionnaires. I looked into that, Attorneys Perry and Keyes, and of course for the state, that creates a problem under our summoning process. And if they're summoned in, the only way to do that is successive and immediately before the jury trial. We cannot have them come in, let's say in June, and fill these out for a report date in October, and that has to do with the language of our statutes. And so because of the confidentiality admonitions, of course, not only for the prospective jurors themselves, but the court's taking the steps to seal even the proposed questionnaires. I'm going to deny the request that the jurors be summoned in to complete the questionnaires and proceed with what we have been talking about, and that is mailing them out in the coming weeks. And then I think I've already addressed number 4. I indicated that all received questionnaires would be put on a flash drive. My only question to you is, are you also looking for anything related to the juror qualification, the initial step of this? If you recall, our clerk of court, Monica Paz, talked about in an email about we're going from a 1-step to a 2-step, and so the first step was sending out the 2,500. And so I wasn't sure how comprehensive your point number 4 was.
We are requesting that all returned documents on this case, including that initial step, be turned over to the parties.
So anyone who even requested a deferment and got one, let me talk with Monica and work on that. I know there's a procedure, I believe, in the statutes that you can go directly to her. Usually they come back to me and ask me if I approve, but we'll work with the parties to make sure you have that information as well. All right, I believe that covers everything then in that motion. I wanted to tidy that up today. Anything else we need to address today from the state,
No, Your Honor.
from the defense?
No, I don't think so.
All right, thank you, everyone. We are in recess.